What's up, STS Nation, and welcome to another episode of Surviving the Survivor, the podcast that promises to bring you the very best guests in all of true crime. As you know, it is week 2 of the Vallow Daybell trial, and things are taking an interesting turn. We're going to get into all the details. It appears Lori had a bit of a meltdown in court on Tuesday, and on Wednesday. Now, court ended abruptly, and we'll explain why. Of course, it is the trial of the so-called Doomsday Mom, the wildly twisted story of a seemingly loving mother, a self-proclaimed devout member of the Church of Jesus Christ of Latter-day Saints, who clearly veered way off course and became involved in the deaths of as many as 5 people, including her very own children. Best guest here today, we've got Gene Fisher, recently retired after nearly 33 years of service at the Ada County Prosecutor's Office as the Special Crimes Unit Chief. During law school, we talked about this last time, Gene interned at the prosecutor's office before being hired directly out of law school in 1989, and she used to hang out at the prosecutor's office all the way back in high school. By 1997, she became the supervisor of the sexual assault unit and has focused on those cases ever since. And then another Boise attorney, Tara Malik, is in the house. She's an Idaho licensed attorney practicing in state and federal courts in business and commercial litigation, and has experience in both civil and criminal law. And just by matter of age, probably not the same experience as our next guest, Tim Jansen, the famed Tallahassee defense attorney. When you get him going, it's hard to stop listening to him because he's so good at arguing as an attorney should be. And he'll probably do it for us this evening. He's a partner in the firm that bears his name, Jansen and Davis. He's handled all kinds of complex civil, administrative, and criminal litigation. He also spent 5 years as a federal prosecutor, and he's been with us for the Dan Markel case and is back today. Of course, a couple of quick housekeeping notes. Please follow us on Facebook, Instagram, Twitter. We are at Podcast STS. That's where I put out all the show times. You can become a YouTube member. We love that. And you can help support us at Patreon. Gene, you've been a prosecutor for many years. Today, court abruptly ended right around noon local time. No one knew exactly what was happening. It turns out that there was a death in the family of prosecutor Lindsay Blake. Obviously, condolences to her and her family, but what does this do for the momentum of a trial in just the second week to suddenly end court? There will not be court Monday. What does it do for the trial itself?
Well, I'm sure that they are going to have to do a little bit of rejiggling to cover some of that, whatever she was going to cover. But I think that they'll regroup in a matter of time. These attorneys have all been working together for a long time, but they might just need a little bit of time to regroup and reorganize. But I think that they'll be fine. It gives them a little bit of a moment to think out their strategy a little bit, unfortunately, but I think they'll be fine.
And Gene, I'm just going to mute you because there's a funky audio glitch coming off of you. If you're not on and you guys can mute yourselves, that would be fantastic. My Knit Saloon says, hi, STS Nation. Greetings from a northern Sweden, awakening spring, nighttime here. Glad to see that you're staying up with us. Tara, prosecution put out a statement that reads, there has been a death in the family of one of the prosecutor's lead attorneys. We found out that is Lindsay Blake from Madison County. The court and defense have been gracious in allowing the prosecution to adjust to this personal situation. Yesterday, we ran into this Lori Vallow meltdown that we'll circle back to. That was kind of a strange situation. There was a little funk in the air. And then today, court adjourns after there were a few sidebars, and we're finding out no court Monday. Same question to you as to Gene. What does this do for the overall momentum of a trial in a case like this?
I think weird things come up in trial all the time. Certainly, everyone has a personal life as well as their professional life. It's not unusual in the midst of trial that something comes up. Obviously, a death in the family is one that is not as common of an occurrence. I think everyone's going to be fine here. These attorneys are all professionals. They've been doing this for a while. The things that it'll affect are the timelines they've probably both set out. So the attorneys on both sides have kind of mapped out when they anticipate they're going to be putting on certain witnesses. So there's going to have to be some rejuggling there. But I think, I think it's a hiccup, a small hiccup. I don't think that it's going to really have a potential huge impact or waves as it relates to the rest of the trial.
Rhonda says hi from North Dakota. Marie Hernandez, hoping we're all having a great a day as she did, and dry conditions. Stay safe, Marie. Tim, to you, you're a veteran defense attorney. You've got this case. You're defending Lori Vallow. You're in a rhythm. The state says we've got to talk to you, Judge Boyce, and suddenly court is adjourned. No court Monday. What does it do for your rhythm, and what would you be doing if you're the defense attorney?
Normally, since it's not the defense's case, you would think it's a blessing for them. They can get together, figure out what's been going on, get the witnesses, see what they've done, see where they need, what holes they need to fill, what witnesses they may or may not call. My curiosity is whether they told a jury why it's being suspended or why they're not going to have court. If they did that, I think that would only help the government because it would make them reflect on death, a loss of life, again, something that the defense probably doesn't want them thinking about on this trial. But, my big trial, we had COVID. We had 2 COVID episodes. We had to stop for a week. And we had experts from all over the country. So things happen in trial. Sometimes they're a blessing. The state probably, you never know. Sometimes it could help them. Maybe they had a witness that wasn't available. It can work both ways. But like I said, these are professionals. The state's carrying this ball. The defense is just doing cross-examine right now. So the state's probably got enough resources to get through this. I'm sure they're concerned about their lead prosecutor and the death in the family, how it's going to affect her. We don't know how close the person was. So it can go both ways, but it's going to move on.
And Shaq is in the house. I'm convinced it's the real Shaq pretending to be the fake Shaq. Shaquille Oatmeal. Cindy Neufeld says, hi, all. And Marina, the archetype reader. Hello, family. Greetings from beautiful Marbella, south of Spain. Let's be grateful for not being horrible human beings like this subject of our discussion, seeing the positive side. And I have to say, Marina tweeted something absolutely amazing to me on a day when I definitely needed it. So I really appreciated it. And I retweeted that at Podcast STS if you care to take a look. Tim, right back to you. Probably a bad idea because now I'm definitely going to be called a sexist, but this has come up in the earlier shows, and that is how Lori is presenting herself, dress, behavior. She's been smiling and laughing and giggling, but she was also wearing black last week, and a couple of jury consultants said not a great choice. Today, she was wearing black pants, a black jacket, and black boots. She's got her feet shackled, by the way. She was smiling and chatting, quite a turnaround from yesterday. How important is it for the person you are defending, the defendant, to have a proper look and proper behavior as the jury is watching everything in that courtroom?
Well, this part of the trial, that's the most important job for the defendant. How they act, how they look, how they respond, and how they dress. You don't want them dressed like they're thumbing their nose at the proceedings. You don't want them to look like they could care less. It's not that big a deal. We have to remember she lost her children. 2 of her own children were killed. And she's acting like this. It gives a really negative vibe towards the jury. The jurors watch everything the lawyers do, everything the defendant does. They say not to read into it. They do. Jurors are real people. Just like when you're with your family or you're at a party and someone's telling a story, you're listening to how they tell that story, and you're making judgments not only by what they say, but how they say it. And it gives you a good idea for someone you don't know. You develop a sense of who is this person. I think the defense lawyers don't have any control over her. I think it was a really bad motion for them to come in and say they wanted her to be excused from the court. I think the arguments were really hollow. Most defendants that don't want to be in the courtroom is because they're trying to escape, not because they don't want to see what the evidence is going to be against them. I think the judge made the proper ruling, keeping her there.
Last thing you want to hear is a guy who lives in Miami Beach whining about the weather. So I'm glad Susan Silver did it for me. Greetings from rainy Florida. And right on cue, it sounds like you can be able to ride Noah's Ark outside momentarily. The rain is dumping down. So if the screen goes blank, you know why. But Gene, to you, do you think some of these jurors and maybe what percentage of them already have their mind made up one way or the other?
Well, I mean, I don't know. They've certainly heard a lot of, they've heard the opening statements so far, and they have had a good start with the detective who talked about finding the bodies, and just how horrible that setting is. But I think it's, this question that you talk about what she was wearing and what her behavior is like. When you put those things together, and it's how bad the scene was, what her reaction to this has been, how she looks and how she's reacting, I think it's really hard. I think it must be very hard for the jury to not already have some ideas going on in their mind about what's going on. I mean, if nothing else, they're looking at her and thinking, there's something really, really wrong here, and this is crazy. Now, they might not have decided the proof of the case yet, but they're definitely looking at this and looking at her, and it's just not adding up. They're not seeing a very remorseful, sad mother. They're not seeing what normally you would anticipate. And remember, we know this. She's seen all this evidence before. It's not like yesterday it came in for the first time and she was, shocked and amazed at what was coming in front of her. The defense attorneys have done their job and they've showed her everything that's coming. So this didn't come as any surprise to Lori. In the morning, she was bright and cheerful and laughing. And something happened over the lunch hour, and she made the motion. She has had issues with mental illness, but I just think it's a big play.
And let me just get easy here. To that point, we did report, and people did report that she appeared to be sleeping in court. A few reporters who were there say that she was in fact just sitting there with her eyes closed. I'm not sure exactly how they were able to make that distinction, but for the record, according to more than one reporter there, she was not asleep yesterday afternoon, and we will get into some of those details again. But Tara, to you, one of the things that interests me is obviously the behavior of the defendant. And today, when the state was once again questioning the Detective Ray Hermosillo, Lori was described as looking back and forth between the prosecutor and the detective as questions are asked. She also looks down at her notes her attorneys are taking during questioning and is taking copious notes herself. What kind of notes would Lori be taking at this point? And as a defense counsel, do you direct your defendant to take notes during the trial?
Well, we don't know what kind of notes she would be taking at counsel's table, but you do ask as an attorney, you ask your clients, usually you put a notepad in front of them and you're like, if there's something that I need to know, jot it down on the notepad. Don't lean over and whisper it in my ear, which is the tendency. It's, to have someone pulling on your arm and saying, hey, that was wrong. And you're like, please stop talking to me. I'm focusing on what's going on here. So I would anticipate that the note taking was something that was prearranged with her attorneys, that they advised her, write down your thoughts, write down your questions. If there's something that you think we should follow up on, jot it down. We'll talk about it during a break, or we'll talk about it right before, cross-examination starts on these witnesses. So that's what I anticipate. I don't think it's unusual or odd to see someone at counsel's table, a client on either side taking notes. I don't think it's unusual that, you'd see kind of what I call the volley, right, between the question and the answer and kind of going back and forth. To me, it shows that she's paying attention to what's going on, or was at that point in time. And so nothing really unusual there, but I would certainly be curious to know what her notes say.
I would too. Maybe she'll show us one day. Jessica K writes, hello, everyone. Yay, it's Tim with the good hair. Followed by, hello from Tallahassee. Wish I lived in southern Spain. And who does? Marina, who asks, what is Rachel Weisz doing here? I know nothing about pop culture, but she's an actress. Do you get that, Tara? Do people say you look like her?
I do get that occasionally, yes.
Marina is on point then. So there you go. Tim, to you, same thing. I mean, do you have a rule of thumb with your defendants in terms of taking notes? And also, do you instruct them, please don't laugh or giggle, just keep a stoic face? What do you tell them?
Well, you tell them you want them to take notes because you want to give them something to do so that they're not looking at the jurors making faces or bothering you when you're trying to object. You don't care if they take notes. You don't care if they doodle. Some do doodle. Because some parts of the trial is going to be very boring and some's going to be very emotional. So you can never prepare a defendant for the exact proper reaction to a question, and certainly not to the part where they show the dead bodies of the children. So you ask them to take notes or at least be jotting things down just to keep them busy work, because they can't really do anything. And sometimes they feel comfortable doing that because it gives them something to do.
Gene, back to you. We had Dr. Pearson on the show. She's both an attorney and psychologist, a jury consultant of sorts. She said that she listened very closely to the opening statements, and she got caught up on the fact that the defense in their opening statements said that there was not enough evidence as opposed to declaring that their client is not guilty. You're a seasoned prosecutor. Do you see any distinction here between not enough evidence and not guilty? And then I'm going to get into, there was a little press gaggle yesterday with sort of interesting answers from the defense, almost acting a little hopeless and hapless. But what do you make of that distinction?
Yeah, I didn't hear the defense opening. I heard the prosecutor's opening. But thinking about the charges in this case, one of the charges, of course, is conspiracy, and conspiracy, is where two people can make a plan and then one person actually acts on it. And so I think that when they start talking about not enough evidence, I immediately go to they're thinking about the conspiracy in this. It may be difficult to prove that she actually was the one that murdered these children, or the sister-in-law, Tammy. But the conspiracy is a very strong charge, I think. And so I think by talking about not having enough evidence, I think that's where they are going with this, or trying to go with it, because there's certainly going to be plenty of testimony to show interactions between Chad and Lori, and there is all this other circumstantial evidence about not knowing where the children are, not disclosing where they are, making statements that are contrary to where they actually know what's happening with each other. For instance, Chad saying he hardly knew Lori when they'd already been married for 2 weeks. Things that they all have some circumstantial pieces and parts to. So I think that it goes more to the circumstantial nature of that and this conspiracy charge, which is where I think they're headed with that.
Thank you. And Melinda writes, Nagawaka, hope Carm is feeling the love from us all in STS Nation, loving another great podcast from Queensland, Australia. Morning here. Good morning to you. And she's back. She will be back this Sunday. We had to change the schedule up, but this Sunday night, we're going to have some female ex-cons talking about what life is like in the Ada County Jail and what it could be like in prison for Lori Vallow. It's going to be an interesting podcast. Hopefully they don't throw my mother in prison at any point soon. So hopefully she stays safe. To you, Tim, John Pryor, he is Chad Daybell's defense attorney. He showed up in the courtroom today. He was wearing a T-shirt, and he was watching from the audience gallery. Have you gone to other trials where you have a co-defendant where the case is severed? Is this typical behavior? And what's he doing there in terms of, from a legal perspective? What's he trying to feel out?
I'm not sure why he's wearing a T-shirt.
Yeah.
In any courtroom, nevertheless, a co-defendant of the wife. Absolutely, you go there because there's many things you can get from it. You're going to get to see how this judge rules, how he runs his courtroom. You're going to see how the prosecutors do their thing. You're going to get to see the case, what kind of case they have. You get a flavor for the jurors, how the jury selection is done, where the jurors are from, how they're interacting. And you just need to see what the government has, what the state has, what the witnesses say. You don't want to wait until you see a commentary on TV or when you have to order a transcript if the client can't afford a transcript. You want to see exactly what the government's going to outline so you know where your strengths are, where your weaknesses are. But going in there with a T-shirt on, it just smacks of disrespect for the court and the whole proceedings. And I'm sure the judge recognized him and probably didn't appreciate that. But it just, I don't get it. I don't know if he's court appointed. He's a public defender. I don't know that.
Yep.
But I don't think any private lawyer would walk in the court with a T-shirt on to observe a murder trial.
He is a public defender, from what I understand. Tara, to you, Chad Daybell, John Pryor was asked about his client today, and he said that Chad is not watching the trial from the Fremont County Jail. Number one, can a defendant in Idaho, can they typically watch if they're tied to the case, I guess? That's question number one. And number two, is it at all surprising that he's not keeping tabs on it?
Yes, they can watch the trial. And would it be typical? Probably not something that I would be going out and speaking to reporters about and saying, well, my client doesn't really care and is not watching. I mean, I think in these sort of situations, it's better to not say anything at all, if that's the true answer here. I think part of the problem with that is what some people have kind of picked up on with Lori Vallow. It's this like disconnect. We expect that someone who is at least hearing evidence about the murder of her children is going to be a little bit more remorseful or, going to show a little bit more emotion than so far she has been. And you would expect the same thing, from, I think, Chad Daybell. I mean, these are very serious charges, and any sort of behavior that makes it seem like they're treating it flippantly, or that, they're not giving the case kind of the respect that it deserves, given the subject matter here and the serious nature of the charges, I don't think works in favor for either one of them.
And Baby Doll, shout out to you. And she's also sending a special shout out to the man with the good hair, Tim Jansen. Tim gets the heart emoji. Gene, since you're the non-criminal defense attorney on the panel, I went back and listened. There was a quick interview after court yesterday with Jim Archibald, the defense attorney for Lori Vallow. And one of the reporters asks him, how did it go, Jim? And he says, you never know, do you? And then they ask, do you think Lori's going to take the stand? And he says, I don't know. We always make that decision at the end. And he's asked, what do you want to say to the people of East Idaho? And he says, I hope they have better things to do than watch this trial. He didn't seem very enthusiastic. Are you excited to hear that kind of response if you are the prosecutor?
I just think it's, this is starting to sound all too familiar. I mean, if you don't care enough about your own personal, professional, how you are in court as a lawyer, I guess that's one thing. If you don't have anything better to say to the press, you're best to just say, no comment, but to just sit there and tell this community that they hope that they have something better to do than to watch the outcome of this trial is just really so disrespectful. And and they're not only to this community here, but everywhere. I mean, he certainly knows the attention that this case has gotten, and there are very few cases that have come forward that have so many murders attached or so many homicides attached to these two people under these circumstances, with all the craziness and the total disregard in which these, the children were their bodies were destroyed. I mean, it's just a slap in the face, and it's completely unprofessional. And he'd just be better off, the two of them, John Pryor and Jim Marshall, better just to zip it and say no comment if they had any sense about him. I mean, remember, John Pryor's got to come back here and try another case. I mean, this is going to happen here in Ada County. So he's talking to his jury pool, and their jury pool's watching him. Just poor form all the way around.
And Lori says, Lori, let's not even call her by my name in all caps. And then says, I can never understand why she would do that to those babies. Tara, not to put you on the spot. I mean, the state came out and said it was about money, power, and sex. Any further thoughts on motive here as to why she had to kill the children? Obviously, we've heard about the zombies, but have you thought about it anymore? Has the picture become any clearer for you?
I think in any case, both sides are going to have to find a theme. And I know we've talked about it before, but also a jury and wants to know, the reason why. They want to know the motive. And I think the money, sex, and power theme is a good theme. I think it's very punchy. I think it's something that people can understand. And so long as the prosecution kind of carries that through from beginning to end of the case and keeps it consistent, it could be very persuasive as a reason why. It certainly seems like Lori, desired a certain type of lifestyle. And to me that, she was going to get it. I mean, she had a vision for what her life was going to look like, and that vision didn't necessarily include these children as a part of it.
And Tim, to you, back to this interview with the defense attorney. So he says, I hope they have better things to do than watch this trial, to the people of East Idaho, where this heinous crime, these double murders took place. He's also asked about the death penalty, and he says it's a major relief the death penalty is gone. And someone asks him if Lori trusts him, and he says, I hope she trusts me, not yes, she trusts me. Number one, you've handled a lot of high-profile cases. How do you handle the media? And would you ever be that meek in your response or that timid in your response whilst defending your defendant?
Well, I think he told the media exactly how much he's going to put into the case by saying, why would I come here and watch this case? I'm not going to prepare for my case. It's just stupid. And lawyers sometimes can be really good lawyers, but terrible with the media. Then you could have a great lawyer that's great with the media, but terrible in the courtroom. And it's very rare and special when you get someone that can do both. And it's a talent, and it's, takes time, because, like when you're trying a case, you're not trying it just in that courtroom. You're trying it in the appellate court also. A lot of lawyers forget that. They don't know how to preserve evidence, preserve objections. When you're trying a high profile case, you're not only talking to the jurors, you're talking to the judge who's watching everything in media, and you're also talking to the jurors. So you have to be careful what you say. You have to be just as planned and organized in your comments to the media as you do in your opening statement and your closing statement. It all has to mesh together. And I think it was just a fool's gold what he was out there talking. And I'm not sure he's used to having a high profile case or talking to the media.
Well, he's in the middle of one now, so he needs to learn quickly. Maybe he should call Tim Jansen for some advice, much needed advice. We answer all sorts of questions here, and this is something that I'm interested in as well. And no one knows Ada County better than Gene Fisher. Gene, Jerry wants to know who brings Lori her clothes, and then I want to follow up with you.
I really don't know who's bringing her clothes. I mean, I presume her defense counsel is bringing her. Ultimately bringing her clothes. As far as who's making her clothing choice, again, her counsel can weigh in on this, and they should be weighing in on this. When I'm working with children who I have to put on the stand, or teens, or rape victims, I sure talk to them about what I'd like to see them wearing in the courtroom, and remind them about the serious nature and that the jury is watching them at all times, and that their nonverbal language is as important or more important. So again, I just think that this is another just miscue is the best way to put it from their defense attorney, because they're the ones that are ultimately bringing in the clothes and making decisions. And if they're not helping her on what to do with her clothing or her hair, or how to dress at this point, I think it's just another mistake. The other thing, just to mention, I think, when Tim talks about, arguing this case for appeal, it's not just for appeal. Well, it is, but, there's also post-conviction relief issues. And, assuming that she gets convicted and then coming back as a defense attorney, and the post-conviction relief comes up that says that they either didn't, they didn't represent me in the way that they could have. And, the judge is looking at all of their defense lawyers' behavior. It's troublesome for the prosecutor too. They have to protect the record in this case and make sure that the defendant is getting the best defense while they're prosecuting it. And if they see things that are so obviously miscued or mishandled, they have to step in too, because the last thing that they want is this case to get overturned on a post-conviction relief because the defense attorney was a bozo, or made such ridiculous statements, or didn't take care of her in the way that they need to have.
Those are great points, Joel. Really good points, because a lot of times the prosecutors not only prosecuting the case, but protecting the case from being overturned. And you'll have some lawyers, I know some defense lawyers, that will come in and say, yeah, I was ineffective, because they feel like they have to do that, because that's not the role. You're a lawyer, you have to represent your client zealously. You don't go in there saying, I'm making mistakes on purpose and I'm going to help you get your conviction overturned. That's the wrong kind of lawyer. And prosecutors see it every day, and other defense lawyers see it.
Yeah.
A lot of moving parts. Gene has to hop off in about 15 minutes, 13 if we're being precise. But before she goes, I do want to circle back to the meltdown seen around the world. So in court on Tuesday around 1:45, after seeing very gruesome and graphic autopsy photos and crime scene photos, Lori enters the courtroom and is described as having a face that is red. She appears to have been crying. The deputy at that point is locking her leg shackles into the ground. She sits down. She's looking straight down. Her mood is visibly different. In the morning, she was chatting with her attorneys and smiling and laughing. In the afternoon, she appears upset. And then Jim Archibald comes out at 1:48 on Tuesday and says Lori wishes to waive her right to not be present for the remainder of the afternoon. And then obviously it goes to Judge Boyce there after the prosecution argues it's important to have the defendant there. Gene, I'm curious, have you seen this, and how often in your 33 years?
I've not ever seen, I personally have never seen a defendant asked to be excused voluntarily because they're just upset. I've seen defendants act very poorly and not be able to control their behavior and getting threatened by the judge that they're going to be excused or they're going to be removed from their counsel table and put into a separate room, to watch it at a different place. But I've never actually seen a defendant come in and say, I just don't want to watch the rest of this. I don't want to be present for the rest of this today. And there are definitely reasons to take a pause in trials at different times. People do get upset. There are emotions that can become overwhelming, and it might be appropriate to take a moment to regather yourself, whether you're a witness or the defendant or something along those lines, where they might take a moment or a small recess to regather themselves. But other than that, I've not ever really seen that. And honestly, I just think it's just such a play on her behalf, and she has seen all this is coming, and this is no surprise. And I just think it's galling, and I'm glad that the judge, I'm glad the judge ruled the way he did. I think he made the right choice on that, and make her sit there and listen to this.
And wish he ruled in favor of cameras, but you can't get everything. Catherine writes, I hope Joel will have Lori Daybell's older son, Colby Ryan. Saw an interview. We are working to get him. Patience is a virtue. And the great Steve Cohen, the wizard. Someone called him the guest whisperer. He's working on it as we speak. Tara, I know with the Alec Murdaugh case, and I think this is a little different, you couldn't find an attorney in South Carolina that was working because they were all watching the trial. This one's not on camera, so it's a little more difficult. But what was your reaction when you got word that she wanted to be let out of court yesterday and go back to her cell, presumably to cry or mope or think about these horrific acts that she committed, if in fact she committed them, which is what they're trying to figure out right now?
Oh, I think it was such a misstep. I think it was such a wrong move, both on her counsel's part and on her part. I mean, it to me, it came off as an act. It seemed to be an effort to kind of make up for the lack of emotion before. I think Jean is spot on. I mean, you see, there is a period of time in a case. It's called discovery, and that's the exchange of information. I mean, we don't do surprise trials. You exchange your exhibits in advance. You exchange your materials in advance of what cards you're holding. And, to come in and all of a sudden say, oh my gosh, you're going to be showing these photos. She's known for months that those photos were going to be shown and what the testimony likely was going to be. And with experts, you're disclosing the expert opinions. And so, when I saw the request, I just thought, I can't believe that an attorney would even go along with this. It just doesn't come off well. It doesn't look good. I think the judge was exactly right on point to disallow it. I think, to Tim's point, you are trying to make sure that the record is solid, so we're not redoing this and retrying this case. And to ask to just be let out, I just don't understand it. It doesn't make any sense to me.
Joel, I think you really have two scenarios. One, she's faking it and wants to get attention, or two, maybe she can't look and see what her deeds did, meaning she didn't do the murder, but now she's seeing what happened. Now she has to see and feel what was happened to her children. Unlike Alec Murdaugh, who killed those people and sat there and looked at those gruesome photos and just looked straight, never asked to leave. And those are the two options.
Yeah.
Yeah, good point. KCL is always in the house, and today's no exception. If I were on the jury, I'd be trying to see her as not guilty until all evidence is provided by both sides and deliberations. But her behaviors would be testing my ability to do that. Tim, this is a pretty, there's what the law says, which is, follow the evidence, and there's what human behavior dictates. Is this a good example what KCL is saying, that right now she's painting a picture that might have a lot of jurors already having their minds made up?
I think she's 100% truth. I think that happens in every case. And I think that's why you get jury instructions before the trial starts. The judge is telling them, because they know natural behavior is to listen and make judgments. And they want to ensure that they instructed them. They instruct them all the way. Every day, you haven't heard all the evidence, don't talk about it. But people do that in life. And we want jurors to bring their life experiences. People meet people and they size them up, and they program an initial assessment all the time. And so when you're at a trial and you're trying to do the right thing, but when the other side is pushing you off that cliff, keeps pushing you by behavior and lack of reasonable behavior, it's hard not to. And jurors will do their best, and I think they will, but it makes it a lot easier for the jury not to give her any benefit of the doubt.
And Tim, I'm just curious, have you ever had a client who said they don't want to be in court? And I mean, how would you have handled that yesterday?
I did have a client that did not want to be in court. he had the Bundy brace on because he tried to escape like 9 times. And throughout the trial, all he did was look for a way to break out. And the Bundy brace, you'll see, if you try to stand up, it locks your legs. You can't run. I've never, ever had another defendant say they didn't want to be there or wanted to leave because they want to participate in their trial. And it's one of the fundamental rights in our country is you get to see the witnesses, you assist your lawyer in cross-examining, and to not want to do that. And when you said that the lawyer said, I'm so glad that the death penalty is not on, is that an admission or a white flag by the lawyer saying, I'm glad they don't have the death? Why would you say that? He should be saying, my client denies the allegations and we're going to fight it the 100%.
All excellent points. Tara, actually, let me go to Jean because her time is running out in just a moment here. So, Jean, in the remaining few minutes, Detective Ray Hermosillo from Rexburg, Idaho, he was on the stand for more than a day, part of this morning as well. He was the one that was talking about, digging up these shallow graves in the backyard. How strong a witness is he for the state? And is that the order that you would have called him in? Kay Woodcock was the first witness. He followed. How important is placement of witnesses?
Yeah, I mean, placement is really important in every case. And I think he's a very strong witness, and they needed something to grab the jury's attention immediately and to grab them in a way that made them really care and have that emotional reaction immediately. That doesn't mean that they have to have made a decision, all things being equal, about is Lori guilty, but they care immediately about why they're there, and they're vested in why they're there. And I am certain that his testimony, live testimony, when he's talking about literally, crawling around on the dirt and the smell becoming so overwhelming and having to have people come in and take turns doing this, that it had that emotional pull on the jury, that they care, they're there for a reason. There's a reason to pay real close attention. And so I think having him there was super important yesterday to set the scene. And then he also gave some other pieces of evidence that really should have planted a big question mark in the jury's mind about, conversations that Chad was having in regard to, where he was, his knowledge with Lori, some of those other things that will continue to move this case forward. But I think that his testimony was really compelling.
Susan Silver writes, I'm wondering if the reality of jail and distance from her cult have deprogrammed her somewhat. We will get Rick Allen Ross back on. He is a cult expert. If you guys didn't see that show, highly recommend checking it out. He's a super interesting expert in the field, had a lot of interesting information about Lori Vallow's headspace and where it's at. Gene Fisher, for those of you who do not know, retired after nearly 33 years of service at the Ada County Prosecutor's Office. This is going on in the Ada County courtroom. No one knows it better. Gene, before you go, I just want to give you some an opportunity for final thoughts. This trial has a weird feel to it. Would you be surprised if they found her incompetent? What are you looking for?
You can't Idaho will not allow a jury to find her incompetent by reason of insanity. So she has had a competency exam. She's been ruled competent in Idaho, and they won't have that opportunity. They're going to have to decide, guilty or not guilty, but there's no insanity or incompetency defense in Idaho at all.
Let me ask just a hypothetical, which you're always dumb, but let's just say she had a complete mental breakdown and for whatever reason could not appear in court. Would they just drag her in there? What would happen? What would the repercussions be? How would it work?
Well, they wouldn't drag her in there, that's for sure. I mean, if she had a full mental breakdown and was completely incompetent and unable to attend, I'm assuming that they would have to take a break in the trial. I don't know that they would have a mistrial. I mean, there have been juries that have been put on hold. It may be an instance where she needs, some mental health or some medication or something that they can do to help her get stabilized. But just having a breakdown or being inappropriate or something along those lines is not going to cause a mistrial. It may cause a pause, but they're watching. Obviously, they're watching that very closely, given the history of this case and the fact that she's already, she already had her motion for being incompetent. She's had medical care and treatment, and they're ready to go. So I don't. That's how I see that playing out.
Gene, look at this. 44 minutes, 59 seconds. I'm getting you out right on time. So thank you so much. It was great to see you. We'll get you back soon. And we've got Tara and Tim, the two T's, and we're going to take some questions and have a good time. Even though it's a serious matter we're discussing, obviously. But Tim, to you, have you ever had a client that just mentally is unfit, that you just don't know how to control? And is there a possibility that this trial gets halted at some point? She seems, and look, I'm just a lay person. I'm a news guy. I'm not a lawyer. She just seems like she's on very shaky ground right now.
Well, if you think about her behavior, when the worst part of the trial was hearing about the autopsies of her children, she acted reasonable. She couldn't see it because she had a reasonable emotional response. That's not mental illness. That could be argued guilty conscience. That's not any mental impairment. Now, could she stand up and start screaming in front of the jury, and the judge could warn her, and the judge would give a curative instruction to the jury, disregard any outbursts by the defendant? But who knows what's going to happen? And when you talk about the facts of this case and what's happened, everything's in play, and all trials are. And this is when he should bring the defense lawyers into the chambers and say, listen, I've given you leeway. You've asked for this. That's not it's not appropriate. If you don't have client control, let me know. If you need me to bring your client in outside the presence of the jury and outside the presence of the media and tell her that this is how it's going to be run, the judge can do that. The judge can get control of the lawyers can control the defendant. Then if she has outbursts, then the court will do what they need to do to ensure a fair trial to the state.
Kathy P., a friend of the show in Arizona. Hola, STS Nation from sunny Arizona. Everyone's rubbing it in that it's raining in Miami today. Thumbs up in Florida. Thumbs up for best guests in true crime. And you're seeing why right now. You've got Tara Malik and Tim Jansen. Hello from Holland to you. Tara, let's go through some of the sort of the specifics of the testimony today. Again, Detective Ray Hermosillo from Rexburg was on the stand for the second straight day, as I lost my notes here. And he said he was asked some gruesome questions. Again, if you guys are faint of heart, you know, just be warned. But the prosecuting attorney starts to ask where Tylee's teeth and bones were found in relation to the fire pit. And then goes on to say that boards were found on top of JJ's body. And then informed the court that similar style boards were found in Chad Daybell's garage, but they were never able to find the identical matching boards. By bringing that up, everything is done for a reason in the courtroom, I would suspect. This seems to be making a case for Chad Daybell's guilt, not necessarily Lori's. So what's going on here strategically?
Well, you've got a conspiracy charge, as Gene was describing before. And so part of what the state is going to have to do here is connect the dots. So they're going to have to put forward evidence showing some connection between each of these people and then tying it back to Lori. So for instance, the boards in the garage, the boards on the body, you're drawing a link and you're saying, you know, the materials were there, right? The materials were on top of the bodies and there were similar materials in this garage. Later on, as the evidence develops and as the state puts on the rest of their case, they're going to start tying in what did Lori know and how do we know that? You know, what was she a part of and how do we know that? So it's really brick by brick building this case up, and it is the state's burden to do so. So even though it seems like gory details and maybe there's not a connection now, they're going to have to tie it all together at the conclusion of their evidentiary presentation. And often what happens is, they're going to put the bow on, during their closing arguments or shortly before their closing arguments here.
Tim, to you, we got Oma, hello from Holland, but KCL is bouncing back in here. And this is Chad Daybell's attorney once again. John Pryor should not be there, the T-shirt man, given he has said numerous times he is not ready for Chad's trial, followed by Cheryl Ashton's question for you, Tim. Do you think John Pryor is trying to see what evidence there is, possibly looking at a plea deal? What's going on there?
Well, he could argue I'm actually working, sitting in there watching the trial, preparing, looking for a plea deal. Every lawyer should always prepare for trial. You usually get a better plea deal when you're prepared and the state knows you have a pretty good case and they have a chance to possibly lose. Some lawyers have a reputation of never trying cases, so they don't usually get very good plea deals. Other lawyers that go to trial and they beat the state and they prepare as they're going to go to the state, then they usually will get a plea when the state decides, hey, I got a problem with a witness. I'd rather get something rather than nothing. And if you've done it long enough, you start to realize where that line is the prosecutor can go. Then you have to go to your client and say, listen, this is where they're at. We could probably get to here, but if you lose, you're going to get life. And the chances are not good in this jury, not good with what's going on. So this is what I recommend. And that can go all the way up until the trial. I've seen people plea on the day of trial when a state witness becomes unavailable. So sure, he should be working. He should be there, maybe not in a T-shirt, but he should be there taking notes and going back and reporting to his client what the evidence is, what the witnesses are saying, and do you have any witnesses that can, deflate that argument by the state or by the witness?
Kathy writes, are there any family members at the trial in support of Tammy? It feels as if she's been lost in the trial so far. The answer I know is Kay and Larry Woodcock and their extended family was in court today, but I am not sure about Tammy Daybell's family, but that is a very good point. It always seems like there's one victim that's sort of forgotten in all this. In the Murdoch trial most recently, we heard a lot more about Paul than Maggie, the wife, but I don't know if Tammy had family there, but I'll work to find that out. Misunderstood. I'll pay you for this. Hey, STS Nation. Joel, your hair is just as nice as Tim's.
I agree.
That's so kind. So Tim, back to you for a second. You always find things out when court begins, and something that made me do a double take was they discovered silencers in either Chad Daybell's home or his storage facility. I believe it was a storage facility. And then when questioned today, Hermosillo, the detective, says it was extremely suspicious to have those guns along with everything else we located. We took photographs and took the guns out of the residence because when we went inside the residence, the door was broken and unable to lock. We held on to the weapons for safety. I don't know if I'm a juror and I'm hearing that there's silencers being found. How problematic is that?
Well, it is problematic because silencers are illegal unless they had a license. I doubt they had licenses. Jurors are going to say, okay, these people were having weapons and a lot of things that would lead to violence. There's no excuse for having a silencer. And I guarantee you somebody in the one juror is going to say silencers are illegal. You can't have them. You have to have a federal. So it's another thing that the state's going to use against them, that they're prone to violence, preparing for violence. And the evidence showed they acted out and committed violence. And they did it on their own children, or she did it on her own children.
Jenny writes, I'm putting money on Chad. It's funny. Chud is a good friend of mine, Steve Chudnick. Shout out to Steve Chud. I'm putting money on Chad. I'm confused now. Never going to trial. Once they see how fast the prison doors lock on Lori, they'll be making a guilty plea to remove the death penalty. Tara, do you agree with that?
Boy, it's hard to tell, especially with this defense attorney. Maybe. There's certainly the possibility that that'll happen, and that, he will see that the prosecution is prepared in this case, and see the writing on the wall and figure that, there's a risk there in going forward and try and make a deal. Whether or not the state offers that deal at that point in time, unknown. You get to a certain point, when I was a prosecutor, you just get to a certain point where you're ready to go, and if you've got a strong case and you have strong evidence, and if they've waited until the last minute and you've got all your witnesses lined up, you've done the preparation, you may not offer a deal. You may just say, too bad, so sad. If you want to plead guilty, plead guilty. But, we're not giving you any sort of deal on the table. Now, I will say, always a risk, right? Whenever you have a jury, you can't predict what a jury is going to do. And there's a certain amount of risk that's involved there, and that the state, I'm sure, will be considering in case of any sort of deal that they're going to extend or offer. But yeah, could happen.
Drive-in fan says JJ was a burden and Tyler was a rival. Ty Lee, they had to go. So that is the motive from the perspective of Drive-in fan. And then we've got a hello from London KCL, appropriately pointing out that East Idaho is probably hoping for justice, unlike what Jim Archibald alluded to, that they shouldn't even be interested in it, thinking about something else. Tim, part of what was put into evidence today is video and calls from jail visits. And they go over this with Lieutenant Jared Wilmore of the Madison County Sheriff's Office. He's in charge of communications in the jail. And they say that they play some of these recordings. Lori begins by saying, "Hi, babe," and asks Chad if he's okay. He says they're searching the property, so Mark Means will be talking to you. Lori responds, "Okay, what are they in the house?" Chad says, "No, they're out on the property." Lori asks if they are seizing stuff. Chad says, "No, they're searching." As the call is being played, Lori is looking around. What kind of impact does that sort of stuff, like visual media, have on the jury? Because it looks awfully suspicious, right?
It does, because there's not much denial, shock. Why are they there? What could they be looking for? It was more like she was trying to get information, like, what did they find? Where are they looking? And I know she was in jail because she didn't produce the kids. All those calls are recorded. Prosecutors listen to them all the time, especially in circumstantial evidence cases. Defendants always say something that the prosecution can use against them. And I say always, I mean always. They never, if they was anything valuable, they probably wouldn't play it. But it sends a signal again. These two are co-conspirators. They're talking about the conspiracy. It's really in furtherance of the conspiracy because they're trying to obstruct, try to cover it up, or not say anything. So it's relevant. Jurors going to listen how they responded, what questions they're asking. They're going to form impressions about whether they're truthful, and were these people innocent that were screaming denials, or were they just trying to find out what the state was finding?
Brooke Tara asks, are accused suspects in Idaho ever required to wear handcuffs during trial?
Not usually, unless they're presenting some sort of danger to those around them. It would be highly unusual to have someone in handcuffs, especially in handcuffs and visible, and that has an effect on a jury. And these jurors take their job very seriously. As I think Gene and Tim had mentioned before, they're watching everything from the minute people start walking into the courtroom. And so having someone who has not been deemed guilty yet walking in with handcuffs can have a prejudicial effect.
Idaho Mom reports Daybell trial coverage 2023. Idaho Mom reports survivingthesurvivor@gmail.com. Contact me. We'll get you on. We need you. We need an insider. She writes, I'm in the courtroom every day. I saw it with my own eyes. She was mad because she didn't get her way. She was acting like a petulant child. She realized her feminine charm did not work. Tim, to you again. We went over this, but and by the way, super big thank you to Diane O'Brien for the super sticker. Super thank you, Tim. If that happened to you in court yesterday, and she's your client, tell me the conversation, and you can get into your lawyer character that you do so well when you start doing your closings and your opening statements. What would you say to her?
I would take a break and I'd tell the judge, we need to speak to our client privately, and go in and read the riot act to her and tell her, if you want to act this way, let's just tell the judge we want to plead guilty, because all you're doing is hurting everybody. The juror's going to hate you. The judge is going to hammer you. You have to control your client, and sometimes they're not controllable, but good lawyers know how to control their client. You got to find what is important to them. And I probably agree. She's probably used her feminine charms all her life. She's an attractive woman and she knows how to use it. And she has used it, but in the courtroom, that little charm doesn't work, especially when you're shackled and you're looking at life or killing your kids. There's no charm. I can guarantee you there might be one guy on that jury looking at her thinking, oh, she's attractive. But after they testify how they killed the kids and the little boy was found, no one finds her attractive. No one finds her charming. They find her despicable. And they're keeping that in the back of their minds.
Tara, to you, just getting back to some of this video and the jailhouse calls. Lori asked Chad what he wants her to do, and he answers, pray. And she says, what can I do for you? And he says, you should call Mark and talk with him. And it goes on. And then Chad gets another phone call and says, I love you so much. She says, I love you, and asks if she should call him later. And he says, I don't know. I'll answer if I can. I love you, and I'll talk soon. Just strange vibes. Are the jurors going to be thinking the same thing? They just seem guilty. They seem suspicious. If you're the defense attorney, what can you do to stem the harm that's done from these calls?
Well, it's certainly cryptic. It's not the way that we talk. If we feel like we're innocent or that we haven't done anything wrong, you don't say stuff like, can I call you later? Well, we'll see, maybe. It's just strange behavior all around. If you're the defense attorney, I would imagine that you're going to be really pressing home with this jury the state's burden. You're going to find those gaps and those holes and come back. And, part of it too is providing a different explanation, right? So the prosecution, the state is going to come in and explain. They're not only putting on evidence, they're going to have to explain it. They're going to have to string it together. They're going to have to fit it within their theme. And as a defense attorney, you have that same opportunity. You can come in, whether it's through cross-examination or the presentation of their defense, if they decide to put on any evidence or testimony themselves, and provide a different explanation for those calls. You can explain it and say there was uncertainty around the situation, or, they were just scared and they were reacting this way. This is how they act when they're scared. I mean, it could be endless kind of possibilities there, but it's certainly not helpful evidence for the defense.
The answer to this question is Jim Archibald, the defense attorney. But Tim, to you, Lieutenant Joe Powell, a Fremont County sheriff's deputy, took the stand today. And back to the Tammy Daybell question about her not getting enough attention. Well, she got it from this witness, who says that an investigation was eventually conducted into Tammy Daybell's death because she was young and in good health. He explains that he conducted a search on Alex Cox's townhome and helped with the exhumation of Tammy's body. Tim, my question to you is what's tricky here is there are a lot of dead bodies, but unlike the Alec Murdaugh trial, where he was the only one and his son's video put him at that crime scene at that time, here it's not as simple to place Lori at these crimes. So they're bringing up Tammy's death now, but there is no relation to Lori's involvement necessarily. What does the state have to do here?
Well, that's a good question because um, they said she now, after she had an autopsy, asphyxiation was the cause of death. After they checked and saw she didn't have any medications for heart problems, she had some antidepressant pills, and then once they did the autopsy, they said she was asphyxiated, so she was strangled or somehow. Um, I'm not sure how they tie that into Lori. Um, and defense could be saying, "Yeah, I didn't realize that Chad was his killer. I didn't know that he killed people. I didn't ask him to do it." And they're going to have to tie it up somehow. And the judge is probably going to want to have them tie it up. How it became relevant, how it's useful to this case when they don't really have who did it. They don't know who did it. It's certainly circumstantial evidence. It was his ex-wife. And I think the brother was certainly accused of it, and then he died from a brain hemorrhage or something, so he can't go to trial. They're charged with it, but it's hard to get the jury to understand how to take that evidence and apply it to this case. And the jury instructions are going to be very careful that they don't end up convicting her based on what happened to Tammy and not the evidence in this case, because that would be an appellate issue.
I mean, Tim, I know nothing about nothing, but if I was playing Tim Jansen in a courtroom, I'd blame everything on this guy, Alex Cox, who's now dead. The brothers seem to do everything, but it doesn't appear, I mean, it's early on still, that they
Right.
are doing that. Do you think there's any chance that she's acquitted of these crimes because they just can't link her and it's all circumstantial? And
Well,
don't come beat me up, STS Nation. I'm just asking a veteran attorney what he thinks.
well, circumstantial evidence cases, a lot of people, non-lawyers, don't understand circumstantial evidence. They think that's not enough to convict when it really is. I've seen a lot of circumstantial evidence cases much stronger than certainly eyewitness testimony. DNA would be even stronger. But when you have a case based solely on eyewitness testimony, circumstantial evidence cases are much stronger because people's ability to perceive and give eyewitness testimony, depending on the time, place, manner, if a gun's pointed, are really flawed. And that's what most of the cases where you got the Innocence Project, most of those people on death row, there was no DNA at the time, and it was all eyewitness testimony. And that's why the DNA later absolved those people of those crimes. So circumstantial evidence can be important. And in this case, it sounds like that's all they have unless Chad comes in to testify. So I'm curious to see how the state's going to link it up. I agree. You start your first, you witness, you want a strong one. Usually they do it chronologically, and then you want to end with a strong witness also. So I'm curious to see how they tie it together. But I don't have a problem with circumstantial evidence cases, and they need to make sure that they, in their closing, read the instructions. Circumstantial evidence cases are just as strong, especially in a conspiracy case.
And Tara, I just want you to weigh in on that. I mean, that's going to be the difficulty here for the state is actually tying her to the crimes physically. Do they need to do that, or is there any belief on your part that she could potentially be acquitted in this because there's not enough direct evidence to link her?
Well, we haven't seen the prosecution's full case yet, so it's hard to speculate at this point, how much they have. We've gotten glimpses of it, and we've certainly had some, signaling during the opening statements about what they anticipate the evidence is going to show, what they're going to put on. There's always a possibility, even like we've talked about before, there's no such thing as a slam dunk case. And so, especially when it comes to circumstantial evidence, it's the state has the burden and they're going to have to carry that burden. Now, I agree that, eyewitness testimony can certainly be flawed. I think on cross-examination, especially, there's a lot more you can do with eyewitness testimony to kind of decredit it during cross-examinations. I think this prosecution team seems to have kind of their ducks in a row. So far, they seem well prepared. In this case, I would anticipate that they know what they're doing here, and that they wouldn't have brought these charges forward, certainly if they didn't think that they had some solid evidence linking her to these crimes, to the conspiracy.
Yeah, that's a great point. Davey McTeer, Tara, writes, from the judge down to the lawyers, they just don't seem to be up to the standard of what I saw in the Murdoch or the Darrell Brooks trials, in my opinion. Don't forget that Jim Griffin kind of lost all steam in closing arguments. So there's some arguments to be made about that. But what do you think of the showing so far on both sides? And I know you live and work there, so you might have to be careful, but you can tell us.
Yeah, I'll let you in on the secrets. It's with the Murdoch trial, especially. I mean, we've got the benefit of hindsight, right? We are on the other side of it. We saw the whole case. We saw all the presentation from the defense. We saw all the presentation from the prosecution, and so we can look back and make a judgment about the whole thing. We have only begun to see what these sides have to offer here. We certainly haven't seen a whole lot yet from the defense. We're going to see more. We're going to see cross-examination. I think right now it would be really premature to pass judgment on them. We can kind of nitpick on these issues, like, the request that Lori and her team had for her not to be present. I mean, that's just puzzling. But I think it would be an error right now to pass judgment on how they're doing overall. I think, once we get to closing arguments, we'll have a much better sense, for both sides and be able to pass a judgment with a little bit more information and data.
Tara, the voice of reason, keeping us speculators in check. Idaho Mom Reports is back. Idahoans are showing up in full force. You don't do this in our state and get away with it, not if we can help it. So some Idaho state pride, as there should be. And Earth Angel Deborah, Tim, what if she tries to take her life? I assume she might even be in a paper mache jumpsuit in that jail cell, but they've got to be keeping a close eye on her right now, right, Tim?
Absolutely. They probably have her in a single cell, someone watching her throughout the trial. And that's the most important time right now, is make sure her health is good to go to trial. She's not doing something to harm herself. They're pretty good about that, especially on these kind of cases, murder trials. And I agree. We can't judge the defense yet. We don't know what's coming. We can't even judge the prosecution. I mean, we only called, 2 witnesses? So in the Murdoch case, we did have the ability to watch the whole trial. And Jim's closing was very weak. So hopefully we'll judge it later on and not at this point. And, sitting in those chairs, and she can tell you, when you sit in those chairs, it's not as easy as sitting behind a screen talking about the case when you're trying the case, when you're calling the witnesses, when you want to ask that question and you're like, man, if I ask this question, is this going to come in? If I ask that question, is this going to hurt you? Sometimes you have to make that decision, which is difficult for a trial lawyer. You have to make the right objections, timely objections, without becoming a jerk in front of the jury. So there's a lot of stress for the lawyers. So even though they may not be up to the standard, they're under stress also.
Couple more minutes and then we're going to wrap it up. But Nightwood writes, is a doctor monitoring her behavior when attempting to wreak havoc in court? Followed by this question, Tara, from Jessica K. It is speculated that maybe they gave her meds since she appeared to be falling asleep. We hear she wasn't necessarily sleeping. Is this allowed to be administered meds to the defendant? Not an appeal issue? ? What's the answer, Tara?
Well, is she being watched by a doctor right now? Likely not. Could she be taking medications while she's in custody that have been prescribed to her? Yes. Certainly, if she's had some issues with kind of mental health in the past, she has seen a doctor before. They may have given her some sort of medication as a result of those visits, but there's no doctor that would be, on an hour-to-hour basis, like sitting in the courtroom and watching her. I haven't heard of anything like that.
Shout out to Michelle for becoming a YouTube member. We appreciate that. Tim Jansen. So this same sheriff's deputy is on the stand, and he says he was not involved in this now infamous investigation of a paintball shooting incident of Tammy Daybell. Powell says he is not, this is the part here, Tim, he is not aware of where Lori Vallow was on the day Tammy died. If I'm a juror and I hear that, to me, that sounds like reasonable doubt. Is it?
Well, it's like proving a negative. What's the old saying? You still beating your wife? How do you answer that question? Yeah, was that on cross-examination? They asked him.
Yeah, it was.
Okay, so that's a valid question. You don't know, you can't put her at the scene of the crime of this other person. You didn't even investigate where she is, but you're coming in here in this murder trial trying to infer my client's guilt, and you can't even tell this jury where she was. She may be completely innocent of that charge, just like she's completely innocent of this charge.
Dawn is asking, does anyone know why there's no court on Monday? And that is because one of the prosecutors had a death in the family. We will be here, and I will work. Actually, you know what? Monday night, we have Sky Borgman, The Sins of Our Mother director, the Netflix documentary on this. And joining her on Monday evening will be the one and only Gigi McKelvey from Pretty Lies and Alibis, as well as Lori Hella. So we will get into some of the behind the scenes stuff, dig a little deeper into the story per se. That will be Monday night live, 7 p.m. Eastern time. Tara, as we start to wrap things up here, I don't know. Again, I'm not an attorney. Shout out to Ketchup, by the way. But this just has a weird feeling. Yesterday, there was a meltdown. Today, prosecutors have to adjourn. What's your gut telling you about this trial right now?
Oh, I think, buckle up. We're going to see more twists and turns. I'm sure there's going to be more surprises. That's how trials work. This one in particular, the details and the facts so far that have been presented are so kind of outrageous and outside of what we would consider the norm. Even the behavior of, Lori Vallow leading up to this case, including, going off to Hawaii. I mean, these are unusual circumstances. And so, yes, there's been some twists and turns and some surprises so far, but I think we are just getting started here.
And a really special thanks to Idaho Mom Reports for this super sticker. Again, Idaho Mom Reports, Surviving the Survivor at Gmail. Reach out. I'm doing Steve Cohen's job right now, but we'll get you on the show. We'll get you on the show to talk about this. Tara Malik, of course, is a Boise-based Idaho licensed attorney. She practices in both state and federal court. She's run for political office, and you can tell she is top notch, and that's why she is one of STS's best guests. So we thank her. And then you've got famed Tallahassee defense attorney R. Timothy Jansen, a partner in the firm that bears his name. He's handled complex civil, administrative, and criminal litigation, all sorts of things, as well as 5 years spent as a federal prosecutor. And he's got that beautiful mahogany wood, which I am envious of, Tim. But Tim, any closing thoughts, any words of wisdom from a man who's seen it all in the courtroom?
I think it's a long trial. You're going to see more. It's only highlighted because it's in the media and people are there. You don't have as many defense lawyers. At least you can't see them there like we did in the Murdoch trial. But the stakes are high. The crimes are gruesome. You're in a state where, she's not seeking they're not seeking the death penalty against her. So they don't really have any kind of plea deal they can give her, because they're not going to give her like 10 years or something. So they're going to try the case. I agree. Sometimes prosecutors, you get to the point where, hey, I'm ready to go. You pussyfooted around. You don't want to play. You thought we weren't going to ready. We're ready. You're not getting the plea deal. We're going to trial. And I think she's got nothing to lose. And I don't think she'll be acquitted because in these kind of cases, they're so horrendous. Someone's going to have to pay, and she might get a mistrial, hung jury, but I doubt she'll get acquitted unless some witness comes forward or one piece of evidence blows the state's case away and they can get reasonable doubt. But it's going to be difficult. But you're going to see crazy things happen. Who knows? You might get COVID and have to stop the trial. I don't know how many alternate jurors they have. That's another issue all the time. If they don't have enough jurors, and it's a month trial, isn't that right? They said a month.
Yeah, a month. And Tara made a great point. We're so early on; it's tough to speculate. So it's best to see how things do play out in the coming weeks. Harold, anything but dull, a friend of the show. Tim is among the very best legal commentators because of his history of both defense and prosecution legal work, followed by a question here from Omaseo, or I have no idea. Can Chad plead group psychosis or whatever that is called, a folie à deux, and how good is that defense? Tim, is that a possibility?
Can Chad plead group psychosis or whatever that is?
He was part of a cult, I guess.
Well, I guess he'll have to give notice, but I don't think they have insanity defense in Idaho, so he can't plead that. He's either going to plead not guilty, he's going to plead guilty, or he's going to have a trial. Those are his three options. All right, his lawyers in T-shirts walking around the courthouse. Looks like he's going to go to trial.
Ari, you're the Boise attorney. What's the deal with that?
Yeah, he has limited options here, guilty or not guilty. And, maybe he's found incompetent, perhaps like Lori was at some point in time, but, that is not an option in the state of Idaho.
Candy Temple sums it all up. Thank you, Joel, Tim, and Tara, and special thanks to Gene Fisher, too. Great panel. Quick programming note. Tomorrow night, we were supposed to have Eric Bland of Alec Murdoch fame, but he cannot make tomorrow night, so we're getting him on next week. He's coming off a knee replacement, so we are wishing him the very best. We will be covering the Lori Vallow trial instead tomorrow. And then Friday, 12:30 p.m. Eastern time, you've got Great Scott. It's time for your True Crime Phil with Scott Duffy and Detective Phil Waters. And then Sunday night, 7 p.m. Eastern time, she's making her comeback. And we're going to have some female ex-cons on to talk about what life is like now and possibly in the future for Lori Vallow Daybell. Until then, love you, America. I'm off to see my mom right now. Hang on, Tim and Tara.